Can everybody hear me okay? My name's Eric Mayer. I'm a practicing attorney. I am going to speak on a slightly different topic, but I want to begin by saying that one of the things I do want to talk about is global warming litigation as a whole. I mean, this is focused on public nuisance. Myself personally and my firm is involved in global warming litigation, and I think for the audience that we have, it's probably a trend we ought to talk about because I suspect you may see more of it in your courts. The first thing I want to say on this issue of contingent fee agreements, and my own experience, speaking from where we stand, the law is so difficult in this context that we do not, as a law firm, enter into these arrangements on a contingent basis. We do it on a pro bono basis. And in fact, my firm has won the National Law Journal's award in 2007 for pro bono work. We put over $2 million a time in litigation over the permits for coal-fired power plants. And that's an issue. That's an issue that will come to the state courts if it leaves the administrative arena where we opposed it. Because in Texas, if you do not get the result you like in the administrative process, you move into the state district court and the state appellate court system. So I hear the concerns being raised by others, but I'm telling you from the trenches, people are not getting into this litigation thinking they're going to get rich. They're not doing public nuisance litigation thinking they're going to get rich. Why are they doing it? Why are they doing global warming litigation? My own personal, and all these comments are me personally, my own personal view is that people are doing it because there is a lag in the law. The reason people are doing it is because they do not feel that the rights, the public rights for air, clean water, are being adequately protected by the federal government or a state government. And people are frustrated. And people are looking for creative ways to apply pressure. One of the great things about our democracy is, and I agree with Sherry Diamond, I believe jurors get it right most of the time. And one of the great things about our democracy is if you believe that something is going on that you don't agree with and you can find a legal justification to challenge it, in this country you can challenge it sometimes. And our firm got involved in global warming litigation on the request of the cities of Houston and Dallas to oppose coal-fired power plants that were being permitted on a fast-track basis in Texas. And when we started looking at it and started looking at the law, we realized there was something amiss. Public nuisance litigation, I think, fits a little bit in that rubric, and I'll tell you why. If you look at the early cases on public nuisance in this country, they involve disputes between states and cities, or states and states, or states and private companies. Why are they in dispute? Well, first of all, public nuisance generally requires that you have a public right that's been denigrated, a right that's common to everyone, clean air, clean water. And the states, back at the turn of the century, were concerned that other states or other cities were taking action that was detrimental. They were polluting waterways. They were putting sewage, untreated, into the Great Lakes. And so states and cities began to get involved in litigation over this. But there was no EPA, there was no laws yet. And so the body of law that came to apply to this is a body of public common law, if you will, federal common law. And the leading cases on this topic date from the turn of the century. And they were at a time when there really wasn't any type of redress. You had to stop somebody from polluting by going to court, and oftentimes you could invoke federal jurisdiction, and in fact, even sometimes the original jurisdiction of the Supreme Court. And so to suggest that it's a doctrine that is newly created by contingency lawyers, I reject. It's not. It's a doctrine that's been around for hundreds of years, and it's been a doctrine that has worked when, frankly, there weren't a lot of remedies available for the aggrieved party. And in the Bush administration, you had the ultimate showdown on this topic. You know, Massachusetts versus the EPA, where a bunch of states had to sue the EPA because the EPA refused to even evaluate whether carbon dioxide was a pollutant under the Clean Air Act. 5-4 decision, Supreme Court said, you have to go evaluate it. You are charged with the responsibility under the Clean Air Act for determining whether carbon dioxide is a problem. You can't duck that responsibility. And the EPA made a lot of the arguments that you hear in global warming litigation. We can't do it because if we do it, we're impinging on the executive branch. They're out there trying to negotiate a bunch of treaties with other countries. For God's sake, we can't go evaluate what carbon dioxide does. That would be a problem. We can't do it because there are a lot of people out there spewing carbon dioxide into the environment. Why should we, the EPA, just look at it in this country? That's kind of a hodgepodge result. Well, the Supreme Court evaluated all of those arguments and turned around and told the EPA, no, you have to go evaluate it. Congress has passed a statute. You may not like it, but you have to do it. And the EPA has not done it. My own view is they're dragging their feet till Bush leaves office. So where does that leave us? Well, where it leaves us is people who believe they have been injured because the regulatory authorities are not doing their job and have not issued any regulations, begin to look for legal doctrines to help them. And one of those legal doctrines is public nuisance, because it focuses on the unreasonable damage to the victim. And there are cases out in the state courts and in the federal courts where people are starting to use this doctrine to try to challenge what the government is doing or challenge what private parties are doing that they believe are injuring them. Most of the cases have not been successful. Most of the cases have been dismissed. Some of them have been tried, and the most recent one I can think of is the Wisconsin versus NL Industries case. I don't know how many people are familiar with that. It's a public nuisance case that actually went to trial. And again, I agree with Sherry Diamond, the juries generally get things right. And the jury questions in that case are published in the opinion. They make kind of an interesting quick read because they have some special topics that are relevant to what we do. But question number one in that case was, between 1992 and the end of 2006, was the presence of lead-based paint in and on houses in the city of Milwaukee a public nuisance? Jury was asked that question. Jury responded, yes. Okay. Second question. Did NL Industries intentionally and unreasonably engage in conduct that was the cause of the public nuisance? Jury answered that question, no. Question three, did NL Industries negligently engage in conduct that was the cause of a public nuisance? Answer, no. The reason I wanted to read that to you is to make the point that there are cases where public nuisance goes to the jury, and the jury hears the evidence, including the defendant's argument and the state's argument, and resolves those factual questions. In this case, there was an issue. The Court of Appeals determined that the public nuisance here, the real public nuisance that was being complained about, was a little bit more than just having the paint on the houses. And the decision turned in part on whether or not the defendants knew or expected when they engaged in conduct that it was going to cause serious harm. But the point I'm making is that you can try these cases to a jury, and a jury can respond, and you will generally get a reasoned response. I think the trend in this field has been to prevent through motions to dismiss, through arguments that these issues raise political questions, or through arguments that they should not be subject to the jurisdiction of the court and a jury should never hear them. That's been the trend, to try to prevent that type of litigation from being ever decided by a jury. But there are cases where it is decided, and I would put to you that with the safeguards we have in the appellate system, that's probably the right course. One thing I should say about public nuisance is, if you look at the trends in the law, it would be probably a safe predictor that you will not see people able to use public nuisance as a surrogate for product liability law. There are cases now that say, look, we have a developed body of product liability law. This is not, people should not be using public nuisance law to kind of circumvent the requirements under products liability law. It's really should be used in a pretty exclusive area. I mean, it generally requires something that is being brought by a sovereign of some type, whether that be a state, a city, or in a case, we have a case, an Indian tribe. And it's generally being brought in pollution, in the pollution context, because clean water, clean air, these are things that are deemed to be a public right. And there obviously are cases where, depending on the remedies sought, you can have very, very significant issues. The cases that we have been involved in involve money damages. I think you open a whole different set of issues when you begin to file claims on behalf of a municipality or a sovereign and seek injunctive relief, because there are a lot of issues that the courts are reluctant to enter into. One thing that courts are not reluctant to enter into is awarding money damages when somebody has a legal injury for which they're entitled to redress. But you'll see a lot of criticism of public nuisance litigation because the defendants will say, wait a minute, this is simply a way to try to force the trial judge to say what the appropriate level of effluent should be discharged in a lake, and they're not qualified to do that. And the cases that you'll see reported in the state and the federal system, most of the cases, the older cases, deal with questions where either there was no regulatory context or the damages sought are something that are within the providence of the court. The court can well resolve that. I'm going to save a lot of time for questions in this speech because I think this material generates a lot of questions, and we have other panel members who I know have differing views. So with that, I'm going to sit down. Thank you.